Missouri Medical Marijuana Draft Rules for the Dispensary Facility. This is the third video in our reviews of the draft rules proposed by DHSS for medical marijuana. The first was on qualified patient primary caregivers. The second was on medical marijuana facilities generally. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This video covers the draft rules for the dispensary facility. The rule opens by restating the Constitution in a more limiting way. 1. Access to dispensary facility licenses. Subsection A. The number of dispensary facility licenses will be limited to 192 unless the department determines the limit must be increased to meet demand. The rule does not state what the process of increasing the count will entail, who makes the request, or how it will be ruled upon. 1B. 24 facilities in each of the 8 congressional districts as drawn on December 6, 2018. That's the limit. This is the new part. 1C. License for one facility at one location. Combinations of licenses must be approved pursuant to 19 CSR 30-95.0403C. Section 2 covers the requirements for dispensary facilities. This is in addition to the requirements of 19 CSR 30-95.040, which is medical marijuana facilities generally. Dispensary facilities must ensure that all facility employees are trained in at least the following. First, the use of security measures and controls that have been adopted by the facility for the prevention of diversion, inversion, theft, or loss of marijuana. 2. Procedures for responding to an emergency, including severe weather, fire, natural disasters, or unauthorized intrusions. 3. Standards for maintaining the confidentiality of information related to the medical use of marijuana, including, but not limited to, compliance with the Health Insurance Portability and Accountability Act. 4. Procedures for verifying the identity and purchase limitations of qualifying patients and primary caregivers. 5. The differences in the purported effects and effectiveness of strains of medical marijuana available for purchase at that dispensary, and their methods of use. And 6. Recognizing signs of marijuana abuse in patients. B. Dispensary facilities must provide all purchasers of medical marijuana with patient education materials that include at least the following. First, local resources for concerns about addiction, as well as a phone number for the Substance Abuse and Mental Health Services Administration's National Helpline. 2. Information about different strains of medical marijuana available at the dispensary and the purported effects of the different strains. Seeing some repetition? I am. 3. Information about the purported effectiveness of various methods, forms, and routes of administering medical marijuana. 4. Information about potential risk and possible side effects of medical marijuana use, including risk of poisoning, and the phone number for the closest poison control center. Yes, this is actually in the rule. 5. The prohibition on consuming marijuana for medical use in a public place, including the definition of what constitutes a public place, pursuant to this rule. C. Dispensary facilities must require, for every transaction, production of a qualifying patient or primary caregiver identification card. 2. A government-issued photo ID. 3. In the case of medical marijuana plants or seed purchases, a patient cultivation identification card. Section D. Dispensary facilities must report any incident of theft or attempted theft of medical marijuana by qualifying patients or primary caregivers to the department within 24 hours of the incident. Apparently they don't care if it's employee theft, just by patients. E. Dispensary facilities must design their facility and staffing in such a way as to accomplish the following. 1. The general public, qualifying patients, and primary caregivers may only enter the facility through one access point into any area where facility agents shall screen individuals for qualifying patient or primary caregiver status. No medical marijuana may be accessible in this area. Man, those are harder controls than it was eating a strip joint in the past. 2. Only qualifying patients, primary caregivers, and, if requested by a qualifying patient, up to 2 additional persons to support the qualifying patient may enter any areas beyond the facility's access point area. And 3. In any limited access area where medical marijuana is acceptable, the facility shall only allow access at any given time for a number of qualifying patients and/or primary caregivers equal to the number of staff available to serve those individuals at that time. This is a 1-to-1 ratio, folks. F. Dispensary facilities shall not sell medical marijuana until the medical marijuana has been tested by a testing facility, according to the provisions of 19 CSR 30-95.070, and has been verified as passing all required testing. G. Dispensary facilities that sell ingestible marijuana-infused products shall comply with the applicable food safety standards as set forth in 19 CSR 20-1.025. Some of the requirements in this draft rule are ridiculous. Some of the phrasing in this draft rule is ridiculous. We could do a comedy routine on this draft rule. There are methods by which you can submit suggested changes. I suggest you do so. There was always going to be an airlock system. That's not new. There has to be, according to the Constitution, and that's fine. A 1-to-1 ratio, okay, that's fine too. That's going to drive the cost of your medical marijuana up, by the way, folks. It is going to go up. Some of the dispensary requirements are a little bit onerous, and we haven't even gotten into the in-depth of the security systems yet. But security systems here are going to be tough, and expensive. So it's something to pay attention to. Definitely look at our other videos. Look at the draft rule videos we're putting out. We've got several more that are going to be coming out in the near future. If you are in Missouri, you are a renter or you're a landlord, and you want to ensure that you protect your right to use medical marijuana in the next lease cycle, or you want to prevent a tenant from cultivating medical marijuana in your residence, we have a package of lease addendums that will allow you to tailor the addendum to how you want to preserve that. That is available on the Pat Talks Law website. It's $25. We don't horribly market things and pitch, but that's one of the things we are doing. I think it'll be a big help for you if you want to use medical marijuana, and it can be a big help for you if you're a landlord. So thank you very much. I appreciate your watching. Please hit like, subscribe, hit the alert button, and we'll see you in the next one.